Good afternoon, everyone, and welcome to this webinar. My name is Mercy Cheredi-Chore, and I shall be moderating this session. I'm an associate at CM Advocates LLP, whereby I focus on intellectual property, technology, media, and telecommunications. So in today's topic, as you all know, we'll be dealing with the future of copyright protection in the age of AI. This is one of the most urgent questions at the crossroads of creativity and technology. And as you all know, artificial intelligence is no longer just a tool used in the creation of works. It is actively reshaping how musical works, artistic works, literary works, and even design are produced. In doing so, it places growing pressure on the fundamental principles of copyright law, which include authorship, ownership, and originality. So with this, we found ourselves tackling important questions like who counts as the author of a work when a machine helps create the work? Let's say when an artist uses AI in the composition of a song, who would be ideally be placed as the author? A second question which may come up is who truly owns the final product when AI is used in the generation of content or works? So the purpose of this webinar today is threefold. It will be to clarify the current legal position in Kenya and to unpack the risks, opportunities, and gray areas arising on AI-generated works. The third limb of this webinar will be to chart a practical way forward for creators, policymakers, and equally innovators. So to help us to delve into this topic, we have an exceptional panel today. It's a three-panel panel consisting of Mrs. Sharon Chahale-Wata from 𝐾𝐈-𝐚𝐬𝐬𝐢, who is the Deputy Executive Director at 𝐾𝐈-𝐚𝐬𝐬. We have Mrs. Liz Lenjo, who's the Chairperson of the Copyright Tribunal, and Mr. Munene, the CEO of Phindor Limited. I don't think I'm well placed to introduce all of them to the extent which they should be, given the depth of their expertise, and hence I'd give each panelist a chance to introduce themselves. Maybe we can start with Sharon. Or Liz, or Mr. Munene, whoever starts.
Okay, thank you. I'm happy to be here. Good afternoon, everybody. Good to see everyone online. My name is, as you have been told, is Sharon Chahale-Wata. I'm an IP lawyer. I work at Kenya Copyright Board as a Deputy Executive Director. I'm also an advocate of the High Court of Kenya. I also teach part-time at the university, mostly IP-related courses. Also do a lot of consultancy around intellectual property issues. And I'm happy to be here.
Thank you for the introduction. Maybe Liz may.
Good afternoon, everyone. I apologize in advance. I have poor connectivity issues, hence my video is off. So I'm Liz Lenjo, an advocate of the High Court of Kenya. I'm the founder of My IP Legal Studio, which is a boutique legal consultancy specializing in intellectual property, entertainment, media, sports, fashion, and technology law. I am also privileged to serve as the chairperson of the Copyright Tribunal, which is a specialized court that deals with copyright disputes, and it's established under the Copyright Act. So if you ever find yourself with a matter that deals with copyright disputes, then we would be the dispute mechanism solution for you and your clients, for the lawyers in the room and for rights holders in the room. That would be the place you want, to bring a case before, because our turnover time is anything between 30 days and 120 days, and you have a judgment. And we know IP has a shelf life of a banana, so why be stuck in litigation when you can come to us? So I think aside from that, I also teach currently on sabbatical. I teach at Strathmore Law School, where I teach media and entertainment law. And I am also a tutor with Copyright X by Harvard. which has been mostly hosted at the Go Down, but also now at Kenya School of Law. So it's a course that for those who are interested in copyright, I would welcome them to join. And maybe the next year's class, you may be part of the cohort. Yeah, thank you so much, Mercy, and I'm happy to be here.
Thank you for the introduction. Mr. Munene? So thank you all for the introductions. So a bit of housekeeping before the session progresses. This session will be recorded, so for purposes of data protection and full disclosure. And as the session progresses, please feel free to drop your comments or questions in the Q&A section, which is just below the webinar session itself. So let's start by laying the legal groundwork of copyright protection in the age of AI. So Sharon, so a foundational question. Under the Copyright Act Cap 130, who is legally recognized as an author and how is authorship established?
Thank you, Mercy, for that question. As you rightly said in your introduction, there's need to have a distinction between works that are created by a person and those ones created by AI, because that really is the issue. We cannot downplay the role of AI in innovation now and creativity. We have songs that are now being composed by AI. When you walk on the streets now, you are finding, like I used to see people selling paintings, and nowadays when you see the paintings, they're really just AI generated, yeah? So we can't really downplay that role of AI. But for purposes of this discussion and the law as is, the Kenya Copyright Act, the Copyright Act in Kenya, defines an author as many things. So first, in relation to a literary, musical, dramatic, or artistic work, the Act says that this is the person who first makes or creates the work. So it actually uses the word person. Then it goes on to say in relation to a photograph, it's the person who's responsible for the composition of the photograph. That means the person taking the photo. For a sound recording, it says it's a person whom the arrangements for the making of the sound recordings were made. For audiovisual, this is film and maybe music videos. It means the person by whom the arrangement for the making of the work were made. For a broadcast, it means the broadcaster. For a published edition, it means the publisher. For a literary, dramatic, musical, or artistic work in a computer program, it means the person who the arrangements necessary for the creation of the work were undertaken. And for a computer programmer, it means the person who exercised control over the making of the program. The same act also provides that you establish authorship through one, originality. That means that the work is not copied, it is created by the person. And then fixation, you fix it in a tangible format, such as a written format, a recorded format. And then the creator basically is the person creating the work. So you can see our act has still described an author as a person. And I think that is a common question worldwide, yeah? Mm-hmm. Who is an author? Mostly, IP laws have recognized an author as a person. Protection of IP is usually pegged to ownership, yeah? Because then we are talking about property. And so if you have a car, we want to know who's on the logbook. If you have a land, we want to know who's on the title deed, yeah? Because of the ownership question. So far, worldwide IP laws are placing ownership in a person. So then when it comes to our act, we are also describing an author as a person. So as the Kenyan law is now, we are not yet, we have not recognized a machine, or an AI as an author. An author needs to be a person. That is the provision of the law as it stands. And it's not just in Kenya, even in the US, I know that, and other places, an author is being recognized as a person.
As per the current situation right now, is there any requirement for disclosure when AI is used partly? especially for the applications which have been submitted, if there are any? Are they being accepted with that disclosure?
We have not had a requirement for the disclosure, but given that we are now, things are changing, and we're also realizing people are using AI a lot, so we are now in the process of developing some guidelines in terms of the registrations which are concerned with AI-generated works, yeah? So now we have, there's some processes with government, of course. Once you come up with some of these things, you may need public participation and things like that, but we're going to issue guidelines that are going to help us with the guidelines. I also happen to be one of the people that do approvals for copyright registration. And so I have also noticed like some of these things seem AI generated, but we are now using a system, an online system. So that question of AI had not been put into perspective earlier. So we didn't have a requirement for disclosure yet, yeah? But we are developing those guidelines, which we are going to use going forward. For now, we are not, you wouldn't be sure unless you ask the person, is this AI generated or not? Yeah, but we didn't have the requirement for disclosure before.
Okay, thank you for that. So Liz, so we have a human-centric law, which basically meets non-human creators in the form of AI. With this ambiguity, obviously there may be disputes which may have arisen or will arise in future. So from your perspective, from being the chairperson of the tribunal, how are you handling such cases where the line between human and AI contribution is blurred?
So we recently just determined a matter, and the issue of AI sort of arose, but we could tell that the parties didn't seem to feel like it was an issue. So in the judgment, we ended up just giving, telling the parties to err on caution that, any works generated by AI would be, their copyrightability would be questionable. And we really had hoped that the parties would have also brought that work forward during the proceedings. And even now, as they are the party that was stating that they had also, used AI, because one of the parties said we generated part of the works and we used AI, but because it wasn't brought before us, we were not able to sort of have a look at it, interrogate, and have that and look into the question of what would have been the ideal approach for us. Because again, I think it would be highly dependent on also what 𝐾𝐽 would observe in terms of how technology is being used in the process of creation. When you look at the US and the UK, their approaches tend to be a little different. US has a very human-centric approach that human authorship is important or must be in play. Meanwhile, in the UK, they are looking at what they call arrangements necessary, that, computer-generated works. First, they use the term computer-generated works as opposed to AI, but they also state that they only grant rights to the person making the arrangements necessary, i.e., they're the ones putting in the raw input, making the creative decisions and whatnot. And if they're able to sufficiently prove that, then they would get copyright, or they would be able to assert copyright. So you see, for us, because we are yet to see or have statistics to appreciate how Kenyans are using AI, for now, we may not know what direction to go until we have a matter that is comprehensively brought to our tribunal, and they adduce such evidence that we're able to, and evidence and compelling arguments, and then we see where we would go. And if that doesn't happen by the time the regulations that 𝐾𝐽 is working on are there, then 𝐾𝐽 regulations will guide us in terms of that. And then, again, it may depend also on a case-to-case basis, and then we'll be able to determine. But in an ideal situation anyway, anyone who is using AI, because AI can be viewed to be more of like a tool, then it would be great for them to always keep their files, their raw files, in terms of the input that they give their whatever AI tool that they are using, to be able to prove that they were manipulating and giving the creative input and injecting that originality to be able to create this new work that they want to own. So in the event that an individual would end up destroying that evidence, and they're able to just say, oh, but we generated with AI, of course, there will be that question of what was your input, what was your intervention, what was your extent of creativity input towards creating that work. So I think Kenyans need to start appreciating also how the law of evidence impacts asserting ownership in copyright, especially in the conversation around technology.
I loved how you mentioned the law of evidence and how you need to assert that you actually contributed to the actual works, although they are AI generated. So with that, we'll bring in the creator's voice. So I understand that you have been using AI tools to play a significant role in the creative process which you're undertaking. So from your perspective, what factors should you determine when you, the human user, are using AI so that you're recognized as the author?
I think first, before I even start, I have been creating AI and using at the same time. So two things I want to put across before I answer that question. Currently, you're seeing AI and it's quite easy for people not to find the differences. So I'm going to define two things, which is AI, artificial intelligence, the general idea that machines can learn and do things like we do them. Then number two, there is something specific called AI agents. So AI agents, on the other end, are part of AI, but they do things on their own without a human input. So while we proceed with the discussion, you will see how that comes up. I just wanted to put it across. So first of all, I think authorship or ownership should be tied to the intentional human creativity. Okay? I mean, if I use an AI tool, I give it the direction, I want to shape the output of that particular AI tool, guiding it on how to, if it's a video, for example, edit and then decide what I get to keep and what is discarded, then clearly, in that particular case, I am exercising that creative judgment, and therefore I own whatever comes out. And then number two is, on the other end, rather, if the AI, in this case, is doing is exercising the entire process on its own with either no human input or minimal human input, then in that case, we might say that the AI owns that work. So in my judgment, there are three, I think, common factors or other obvious factors that you can look at to decide whether this work is owned by a human or the AI. So number one is, I think, the level of human involvement. So look at this as, you're looking at AI as a tool, and the human is, or rather the person is using the AI to create something. So we want to judge how much was the human being or the person involved. If if they were fully involved, guiding, directing, and making sure that whatever the AI comes up with is per their instruction, then the person owns. So that's number one, the level of human direction and control. The other thing is the original intent. You see, whose idea was it to create that thing first? Was it the AI or the human being? So if they own the idea, then they own the final product. And then I think it is, the other one is like, how much were you, the creativity. Where did the creativity come from? Is it from the AI or the person creating the product? If it is the person, then it belongs to the person. So I think for me, and I'll give you examples. So right now, with software development, you've seen, or rather you might have seen, that there are tools to help people create websites, applications, and so on. Personally, I use one. And initially, I could take 3 months to build an application. Right now, I'm telling you, 2 days I'm done. And software has two sides. There is the engineering part, where you get to put together all the blocks that define how that is going to work. So if I do that, if I do the engineering and then delegate the implementation work to the AI, then I still own the software. Then it's still my creation. What I know is legally that is not, I don't think it's quite clear yet. But yes, in my judgment, that's how I would look at it. That I engineered, I designed the product, and the AI implemented. Same thing as me, as you know, as a company. We have ideas we want to implement. We hire employees. So I'm looking at the AI tool here as an employee who gets to do the work that I have designed. So then I own that particular product. So in short, I think what I'm seeing right now is AI is extending human creativity. I can't say really it's replacing it. I don't think we have evidence of that, because even when you talk of AI agents, I have not seen an agent that is on its own able to come up with an idea, engineer that idea or design it, build it, iterate on it, and then give us a final product. I have not seen an entity like that. So until we get to that point where the AI, we have a small meeting of AI agents, they sit down and then they decide what they're going to do and they create a product. Then in that particular case, I would say the AI owns that work.
Okay. Thank you, Mr. Modene, for that. A key takeaway from what you have said, it's that AI is extending human creativity, not taking anything away from it. So with that, Liz, I'd like you to elaborate the legal risks which creators like Mr. Munene may face with regards to AI-assisted works. This will be with regards to economic rights, moral rights, enforcements. Where are they most vulnerable?
I think for a creator who gets it right from the beginning, remember I said, as long as you have your evidence, you're able to prove that you generated the work, you're able to prove that you prompted the AI, that human intervention was all on you, the creativity, all those elements Munene has mentioned, you're able to show that. Then even when you bring that matter before the tribunal or any other court, it will be very easy for you to assert that right, to be very easy for you to even enforce any infringement. Because at the end of the day, it would mean that the creator must prove that they actually created the works. So if they're in that situation, then it would be very easy. It would mean that now their strategy would be now to recover what has been lost and how they would assert that intellectual property, especially that copyright. And when you look at how Kenyan creatives tend to approach infringement, they have a very reactionary approach. And I think that is one thing that, creatives generally in Kenya need to appreciate, that when you identify an infringement has happened, you shouldn't react immediately. You are in a better situation when you seek legal counsel and you're able to say what it is or how it is that issue would be remedied, right? Because you find that sometimes the bottom line for most of these creatives is compensation. It's money, right? So if you decide to go online and call each other names and just do what people like to do on X and all these other platforms, they tend to get rid of that goodwill. And then, I don't know about the lawyers here, but for me, I have struggled when I have had clients who did that on social media. So by the time now they're coming to me, my work is even harder, right? Because we had an opportunity to actually negotiate out of court and get a good settlement. But now they decided to get down and dirty on social media, and it just changes the whole equation. So I think, for the developers, it would be just an issue of evidence. And even for the lawyers who are here, then the questions you would be asking your client is, how can you prove this was your work? What evidence do you have? And even now, as the lawyer, you want to see that evidence. You want your client to come to your office with their laptop, or they enter into whatever platforms they are using, and you're able to see that process of creation. Because the minute as a lawyer you're able to see that process of creation, then you'd be able to defend that this is legitimately your client's work and that the copyright belongs to them. So I think when that is in order, in terms of enforcement, in terms of, asserting your rights, being able to claim the moral rights, the commercial rights, it will be very seamless, because now you're able to just take back what belongs to you on the premise of that evidence and the understanding under copyright law that you're able to show and demonstrate that human intervention in that originality and creativity. And I think you're good to go.
Thank you, Liz, for that. So basically evidence. Make sure you have evidence that you actually contributed to the works, which are, although are AI generated, would be basically subject to protection under copyright. So that brings home the complexity of what creators are up against. But of course, this isn't a Kenyan issue alone. It's a global issue. We'd already mentioned a bit of the UK and US comparison, but we may expound on it a bit more. So maybe we can start with Sharon. On when you're dealing with the EU and US and UK on the aspects of copyright protection for AI-generated works, what are the key principles or maybe precedents that Kenya would learn from such jurisdictions?
Yeah, maybe let me start with the US, because I was in a training in the US recently by the US Copyright Office, and they talked to us about the issue of registration and AI. So in the US, AI-generated content is not eligible for copyright protection, as Liz said, unless you can prove there is substantial human involvement. So the copyright protection would not extend to material that is generated wholly by AI. AI-assisted works, however, may qualify for copyright protection if there is sufficient human involvement in the creative process, yeah? The determination of now what is copyrightable at that point is then handled on a case-to-case basis. But then that what they are calling sufficient human involvement is also still a conversation. They're still having to say what is sufficient human involvement and what is not, yeah? However, the US have a precedent. There's a case, Thaler versus Perlmutter of 2023, where the US courts upheld that AI-generated works cannot be copyrighted, reinforcing the idea of human authorship that they have in their law. In the UK, of course, as Liz mentioned, AI-generated works may receive limited protection under the laws that they have. The European Union, the EU Act mentions the obligations for AI systems to comply with IP rights. And then a jurisdiction like China, AI-generated works can be copyrighted, but liability and authorship rules will remain, they have remained a bit ambiguous, yeah? So we have certain jurisdictions are treating this whole question differently. But I think what is needed is to have clear guidelines in terms of what you want to do as a jurisdiction. The global conversation, of course, has been big on the question of ownership and authorship. I don't think there's an agreement yet as to whether AI-generated works can be granted, fully AI-generated works can be granted. There have been several schools of thought on that issue. One school of thought, some people have said, let us use existing IP laws to protect this kind of works. Another school of thought, people are saying, let us have a sui generis system that can be created to protect AI-created works. And then there's a third school of thought that people are saying, let the AI-generated works be in the public domain so that they are not protected or registrable. I liked how Munene described it as a creator. I like the perspective as a creator, and I've heard that from a script writer before, whereby he was telling creatives that don't be afraid of AI that is coming to take your work. AI is actually a tool that you can use to just make your work a bit faster. I heard him mention that something that would take him long is now taking him 2 days to do, yeah? And so for what Munene was describing sounded like what the US are grappling with in terms of human involvement. How much human involvement? The other issue with AI and copyright is this. There are certain AI programs where the machine learning has been done using copyright protected material. like what should I say, the data that you feed into the machine, you're using copyright protected material. Of course, for the machine learning and the data that you're feeding into the machine, you want authentic data. You want data that is correct, because even that AI in itself will not give you correct results if you do not have the correct data inputted, yeah? Someone said that there's an AI program that was used and it was being asked to give an African president. And it gave a photo of a Mzungu, a white man. And that's a question of the data that was input there. It is probably data from Europe or from US, yeah? So you can really not fault that machine. So you see, even for you to use any AI, you want an AI that is sort of, it will give you good results when you put in the question or whatever, or when you use it, it will give you authentic and good results. That means your data for this machine learning inputting must be correct data. Where do you get that data? The question has come where the data is also gotten from copyright protected material. A lot of companies sometimes do web scraping where you find data on the web and that's what is used. There are certain companies, however, that actually license or buy the information that they need so that they can input into their machine learning. So that's another question. Where we have used copyright protected material to do the machine learning, it has been said to be an infringement also. So I think this is an interesting development. And as Kenya, we don't want to be left behind. So we're also following the conversation to see for example, how do we amend our laws and update to respond to the question that is on the ground at this point? Because now if Munene comes to me and says, I've created this music using AI, but it's me still creating, then I should be able to have a good response of, yes, you can register or you cannot, yeah? And I should have a backing of the correct law to say that.
Thank you, Sharon. Thank you for the very, very elaborate perspective on the different jurisdictions. If maybe Liz will have anything to add, especially on maybe taking into note the Thomson Reuters case on web scraping and the use of copyrighted work in LLM settings, machine learning settings, I mean.
So I'm not sure I'm conversant with that case, but the thing I want to add, when you just look at the practice in terms of asserting copyright and some of the issues that a lawyer would need to look into, I think we are in a situation now we really need to start using expert witnesses and advisors when we are bringing such matters in court, because also the only way we'd be able to also shape the law in a way that still encourages innovation is when experts are able to say, in the experience, what can this platform do? To what extent is there human intervention? To what extent is there machine automation and whatnot? And we see that a lot of our lawyers also don't seem to think about the need for experts. And I think they become very crucial. So I think it's something that we need to embrace more so that when you're also building your case and your evidence. So for example, there is one party asserting copyright on an AI generated work. Of course, the other party would probably be trying to say that this work is not eligible for copyright, right? So what evidence would they be bringing to the table to be able to counter the evidence being brought forward, right? It would mean that this lawyer has also found an expert, maybe through their client, who is able to interrogate and say, the client, the other party used this type of platform. This is how it works. This is the evidence we can adduce. And you have the relevant certificates and all that to make that evidence eligible. I think right now, like I said, I cannot emphasize enough the importance of evidence, right? So that then our laws would mirror what is happening on the ground and that they encourage innovation as opposed to stifle innovation. So as long as we are only having one conversation on the legal side, then we may struggle, right? Because again, when you look at the different approaches, the EU, the US, the UK, it also speaks to how their demographic, their citizens are using technology, right? So for us, it's really important that we figure out how we are able to also gather the statistics. Maybe it's through 𝐫𝐞𝐵𝐲. I do know that we also have the 𝐴𝐼 Kenya Association. Such associations and entities and institutions would also it would be good for them to keep such kind of information and statistics and data so that then they can build a case, so that then we're able to say in the Kenyan context, this is viewed as AI is viewed as infrastructure, right? As opposed to being something else. So I'd say that, so that then now, even in any other situation, when you are now interrogating who owns the copyright, you have understood that element, and you have also been able to appreciate how some of these platforms work. Then also now you're able to decide in an academic setting, what kind of platforms are we willing to let our students use? And in other scenarios, what other platforms are available to them? Because as long as there is no understanding of how these platforms work, then we don't know how to draw the line. Because from an academic perspective, it's really important we appreciate what would help in terms of advancing learning, and what would then sort of foster that bad behavior and lead to plagiarism and infringement and all that, right? So I think it's really important that comes into play, and we have more people trying to become technocrats on how technology works, as opposed to leaning only on the creative side. Yeah, thanks.
Thank you for that, Liz. So beyond the legal theory, I'd like Mr. Munene to chime in. Like, apart from the easing of work or the continued use of AI in your work, how has it changed the way you innovate? What new doors has it opened to you? Mr. Munene?
For me, I always look at AI in 3 dimensions. Rather, I ask 3 questions. So question 1 is about money. So how much money am I saving or making? And then the effort. And then lastly, the time I'm saving. So in those 3 dimensions, first I'd like to say this. Our company, we've been running a team of 5 people. If I look at the amount of work those 5 people are doing, I can tell you, without AI, we'll be requiring around 15 people. As a startup, that is saving me a lot of money. Again, you understand, startups do not have money. So for me, that's value in its way. And then it's about the things that I could not see that I can see now. So this is mostly to do with data. I can analyze data. I can afford to build, let's say, analytics, the level of big tech or rather big companies that I could not afford before. And that gives me proper insight into my business, into my customers and all that. And that is equal to very fast growth. Let me give you an example of that. Early this year, we were handling 1,000 customers. As I speak to you right now, we are almost at 1 million customers. So that has been, like, I think 6-7 months. And that growth, I can attribute that into me being able to do most work quickly. So when we talk about AI, really, for me, that is the acceleration in terms of first of all, the creative process. How much time do I spend creating and coming up with ideas and figuring out the best way forward? With AI, as long as I know my metrics, I can quickly figure out the way forward in seconds. That will take me previously that would take me a week and a couple of guys will sit down and crunch numbers. So that is quite clear on our end. And what I'm seeing is, ideally, you look at things like testing products. I can test my product as I build it. So when I talk about the value that I'm getting, to me, it's mostly time. And then number 2 is let me not say correctness, but the quality of products I get to build. You see, as long as I understand my data, I understand my the problem deep enough, then the quality of the product I get to build obviously goes up. And then it means for me more attention and love from my customers. So yeah, briefly, that's how I'll put it. And then in terms of, I think, coming up with ideas, and this is really good, I can build 10 products, or rather, I can implement 10 of my best ideas within a day and then get to pick the best. Previously, that is something I could only dream of. So, and I'm sure this is quite, obvious with most builders, that right now you can test almost, or rather build almost all of your ideas and then get to pick the best and sell that. So yeah, acceleration in terms of how I get to build and deploy products.
Just a follow-up to what you've said. When you're coming up with ideas, what are the practical safeguards which you employ so that you make sure you do not lose any of the autonomy when using AI tools?
Okay, so ideally, I mean, coming up with ideas really for us, it's not, I would say this, we don't sit down and think about ideas. What we do is we look at our customer patterns. What are they mostly interested in? And that translates to data that we collect from our customers. So the analysis of that data and picking the right idea and feature to implement, that's where AI comes in. But AI doesn't get to choose for us. We guide the AI into choosing what we think works for our customers. We pick that, we take to the customers, we do another test, a live test with the customers, come back, iterate back and forth. So ideally, AI doesn't get to take over because, again, I will tell you this, I am not at a point where I can trust AI to do things for me without my. As much as I am developing AI products, I know that is not quite possible at the moment. There are some obvious tasks that you can delegate to AI, but critical business decisions still go back to humans. So we get to decide what goes live. AI only helps us do those, those tedious, those tasks that we think might take us longer time to implement. So ideally, we are still in control, only faster.
Thank you, Mr. Munene. So even as we are talking about the opportunities offered by AI, one of the most alarming threats which we have right now is the emergence of deepfakes. So we've seen global responses to what these deepfakes entail. Like in Denmark, there was an amendment to the Copyright Act to grant individuals ownership over their own body, face, basically personal likeness as intellectual property. So with that, maybe Sharon and Liz, what protections would Kenya ideally borrow from what Denmark had done to shield creators from being impersonated or commercially exploited through AI?
Yeah, I think we need guidelines. We need to promote the adoption of ethical guidelines for AI development that prioritize the creators' rights and they would prevent exploitation and deepfakes. I think we also need to come up with pragmatic ways to train experts and create awareness on the members of the public for detecting deepfakes, so that you can curb that negative effect. Because I think sometimes you're not even able to detect the deepfake. I think we all witnessed, if I'm not wrong, it was a PS that saw a film, a video that was a fake, and he commented on it from his position, and it brought an issue, but he commented on it believing it to be a true thing, so that means that he was not able, and probably all of us, we may not even be able to detect the deepfake very quickly. So we definitely need to come up with guidelines to protect that. I think one of the things that we have recently come across as 𝐫𝐞𝐽 is that we need guidance on the legal infrastructure that we need to put in place for AI-generated works, for all this training data, and even the guidelines on how to detect deepfakes. But also this will need training for many people. This is a new area. We are all training ourselves and learning and getting to learn more and more. And so I think there's a gap in terms of the training that is needed for stakeholders and everybody, but also just the provisions of the law as it is.
Thank you, Sharon. Liz, would you have anything to add on that?
Yes, I have something to add. So I did research to see if, in truthfulness, Denmark is trying to assert intellectual property rights in facial features and everything. And I think it was just, I think someone in leadership who said something, but there is nothing in law that they are trying to implement. All right. So remember, we have data privacy laws. We have image rights, where we have personality rights and publicity rights, yes, which now enable a person to be able to gain from the use of their image, protect themselves. So depending on who you are, you'll be able to decide what strategy you want to use. Do you want to argue privacy, or if you're a celebrity or someone who has some value towards their image, or it was a commercial opportunity, then you're able to be paid rightfully for that work. So as Sharon said, of course, the AI regulations in terms of ethical use are really important. And being alive to the fact that there are some dangers that AI may pose. Like similarly under patent law, you can't get a patent of an innovation that is immoral, something that is likely to kill people. Right. And I think the minute we realize the impact of deepfakes, it may be a strategy we want to employ and say, these are the kind of regulations we have. You cannot create, or any AI that is able to interfere with people's privacy rights or personality rights. Then maybe there would be certain sanctions around that. That may be something we may have in our ethical guidelines. But I think to try and assert copyright or IP on our facial recognition and image and likeness would just be strange in my view. But there is other mechanisms in law where one may protect themselves and also even gain depending on what they want, because at the end of the day, it's the complainant who decides what they want, right? But on the ethical conversation, definitely the guidelines, we may want to think about the approach we've had in patent law, where we do not grant patents to immoral innovations. Same thing even in trademark, where a brand name that sounds has an immoral connotation or an abusive type of connotation, it will not be granted in that jurisdiction, right? So I think it's something that we want to consider in terms of the conversations around AI and how then innovation would be structured around that, so that we also remember we also have at the back of our mind to protect other people's rights, because at the end of the day, also as we create new laws and regulations, the Constitution is at the core, and the Constitution is simply a balance of rights. One person cannot gain to the detriment of another person. So the minute we get our AI regulations right, the minute users and creators are also sensitized on what ethical use means or looks like, I think then we would be in a good place, and we would not have even that conversation or ideology that regulation in the AI space would stifle innovation. We would just be more responsible in terms of how we use technology. Thanks.
Thank you for that. What I got from what you just said, is basically responsibility. Be responsible in the use of AI. So at this point, I'd like to look at the Q&A section. I've seen only one question right now. So it's anonymous. Kindly guide us on the sites where we can find Kenyan legal materials on this topic, as the Google sources are very few. Yes, I agree. At the moment, the Google sources are they are few, just because it's an emerging area. It's still growing. Apart from the usual Kenya law resources, you can always do personal work on your own, like read on your own. As a start, I'd recommend maybe reading a few books. There's a book by Karen Howe on the empire of AI. You can try reading it just to understand the compounding of AI and how Karen Howe talks about the intelligence of compression of AI-generated works. It will be a good start, basically. It deals with OpenAI, and from that you can move to the intersection between AI and copyright law. From the panelists, is there any other source we should give?
I think because we don't have a law yet, however, Kenya, through the ICT ministry, has a AI strategy 2025 to 2030. The whole idea of the strategy was to make Kenya an African AI leader, and they were focusing on 3 pillars: AI digital infrastructure, data ecosystem, and AI research, innovation, and commercialization. So the strategy really was focusing on building local talent on AI and capacity, establishing a robust and sovereign data ecosystem, and fostering ethical, inclusive AI development. Mostly it wanted to focus on some sectors like health, agriculture, and education, yeah? So because the laws we have right now, of course, like copyright, does not make provision on these issues, I think the strategy is good. I also know there's a publication by Strathmore. 1 minute. I think I have the book right here. Artificial Intelligence and the Law in Africa. This is the book. Mercy, you can see?
Yes, I can.
Yeah. It's edited by several people. This one were given at CPIT. I think that would be a place to start. Strathmore University, the Center for Intellectual Property, in finding this, yeah. So as I agree with you, Mercy, we are all reading and researching and teaching ourselves these new things. So that's WIPO also. WIPO has several publications on the conversation, and WIPO resources, the WIPO website, the World Intellectual Property Organization, it's wipo.int, their website. It will also give you a global perspective of the conversations that are ongoing there. They also have several webinars and meetings that are usually free and open to attend, so that you can be part of the conversation or hear what people are talking about and what people are doing out there. So WIPO is also a very good resource for that.
Thank you, Sharon. Any other addition to that?
I think in addition would be the case laws that are there. Because when you read some of these case laws in a very intensive manner, you will see some of those issues and discussions that come up where the judges have observed something and they interrogate deeply, and they may have even some obiter dictum statements that would be relevant into another case and whatnot. So I think I've also benefited a lot from the judgments that I have seen so far, and those reasons that they have been put out there. They tend to shed a lot of light in terms of how AI is working, how it can be appreciated, possibly the do's and don'ts and whatnot. So there we see a lot of good discussions also happening. So I think I'd also encourage, especially for the lawyers, those case laws, when you read them in their entirety, they have a lot of lessons for us.
Okay. Thank you, Liz. There's one more question. Maybe you can answer it briefly because you're almost out of time. What's the view of the panelists on whether AI developers and owners of AI systems should be granted authorship and moral rights? This is a key debate in copyright. Maybe Liz can take it. I think you answered it. You actually answered it.
Yeah, we answered it. So hopefully, when the recording is released, they would listen, because we had a whole conversation to take us back to scratch.
It will. So basically, copyright is human-centered. Regardless of whether the AI developers use AI to whatever extent, it's still human-centered, and the person who will be considered as the author will be the human person behind the works which are being protected. Sharon, Do you have anything to say on that?
Yeah, I see the question is asking what is our view on whether this one should be granted authorship. My personal view, this is not a Kikobo view, this is a personal view as a copyright lawyer. For me, creativity, I feel and I find that it cannot be divorced from the personality. If Mercy and I told a story, our personalities will come through. So I think authorship or ownership being tied to the person for me is okay. What we need to grapple with is, so if I am assisted by AI to create something, then what happens? Because some of the conversations have been, you can't grant ownership to AI, yes, but what about the person using AI? Then another question comes, what about the person who created the AI? Then another question comes, what about the materials that were used to feed the data into the AI? I mean, yeah, it becomes a bit messy. Personally, I think the authorship personality theory makes sense to me. Yeah. But then, of course, because AI is here and we are using it, I really like how Munene explained it as a creator. The way he uses it, to me, I didn't feel like whatever he creates is divorced from Munene. I felt like AI is a tool he's using to help him. I can walk from here to town, but I can also get a car to get me there. That is what I understood from him, how he described it, yeah? So, I mean, those are questions that are still out there, but personally, I think the person-author theory, for me, makes sense, because even the copyright reward theory is tied to that, yeah? That if you create, you need to get a reward out of it, and it's only right that you be known to have created 1, 2, 3.
Thank you, Sharon. I think you're out of time. For the other questions, I'll deal with them personally, but past the meeting. Maybe if you can get one final thought from each of you in a sentence, like an upshot.
Oh, okay. I think for me, I would say AI can be a tool for you or it can be your enemy, depends on your perspective. So you need to decide what perspective you want to take and take advantage of it. But also, Mercy, maybe you can type, I don't know if you can access the chat, you can type our emails.
Yes, I will.
And yeah, if people want to reach out to us, then that would be okay.
Okay. Liz or Mr. Munene?
Sorry, I got cut off. Were we giving our parting shots?
Yes,
My
it's the parting
internet
shot.
did the thing. I think for me, I'd say ethical use becomes really important for the creators. And for the lawyers, I'd say I think there's a lot of opportunity for us in terms of guiding clients, in terms of even opportunities on dispute resolution, advising clients on how to innovate around AI or with AI. I think the opportunities are endless. And even just to speak to the question that Mr. Katana has asked, when creators are ahead of the opportunities, the rights holders themselves are able to create opportunities where they can collaborate becomes really important, because that's what technology does. It has helped rights holders assert that control themselves. Like right now, in terms of commercialization with technology, you find that so many intermediaries have been gotten rid of, because now you no longer need an agent to get to a music distributor, for example. You can distribute your music yourself. So that means then you are in a position where you can find a solution and you're able to say, we have an AI association in Kenya. How do we pull together and say, as musicians, we have a pool of music that we can license, and this is how we work together. So I think the solutions always lie within the rights holders. We don't need to look to government, because government has already given you the right. So now it's up to you to think outside the box and see how best to diversify your opportunities to make more money and to ensure that you are ahead of anyone else who may try to to use your work without your knowledge. If you get ahead of the game, then nobody will ever try and sort of circumvent you and slice you out of the equation. But I would say for the advocates who are present, there's a lot of opportunity. Educate yourselves also on AI and learn even just a few nuances, because they help you, they set you apart in terms of even how you would win your cases. If you end up in arbitration, because we're also seeing a lot of international arbitrations around AI, it's really important that we as lawyers also learn an extra skill, either from a policy angle, from a developmental angle, or developing rather coding and whatnot. I think it's really important as lawyers we have that extra skill and knowledge to set ourselves apart from the rest. And thank you so much, Mercy and CM Advocates. This, I think, was really wonderful.
Thank you. Thank you also, Sharon and Liz. I know Mr. Munene just dropped off. He was very strict on the time. So I think, thank you all for having us. Thank you for coming. Thank you to the audience for listening to us. And even as we come to the end of our discussion, I'd like to hear what you'd have to say past this webinar. You can reach us through the normal channels. I'd also put our email in the chat box in case you'd want to reach us. And thank you. I hope you have a good evening and be blessed.
Thank you, Mercy. Thank you for having us. Thank you, our participants. Mr. Katana, I see you. Kyoko, I saw you. I think Mr. Katana had invited a friend from Europe on the call. Thank you. Thank you for attending.
Thank you. I'll answer
everyone.
All of these answers. Thank you. Thank you. Have a good evening.
Thank you, Mercy. Bye.
Bye.
Bye, everybody.